Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about the Katy Perry case. And the Katy Perry case in Australia is about trademark law. It was just decided by the federal court yesterday, so this one is very, very recent. With Katy Perry, in Australia there are two Katy Perrys. There's the Katy Perry, the American singer, and there's also Katy Perry, the Australian clothing designer. For the sake of the argument, I'm going to call them by their actual surnames and not by Katy Perry, because calling them both Katy Perry gets kind of confusing. So the designer was Mrs. Taylor and the singer is Mrs. Hudson. So we'll just refer to them as Hudson and Taylor. It might make it a lot simpler than talking about Katy Perry all the time. The original designer in Australia, the clothing designer, she established her brand in about 2007, 2008. And around 2008, she filed for a trademark for Katy Perry. She filed for the trademark relating to clothing, and she was inspired by a couple of Italian brands and that sort of thing, and developed a clothing brand around that. Around the same time, Katy Perry, the US singer, started up her career in the US. She started a clothing line in about 2009, which was a couple of years after the Australian designer had started. The problem was that the Australian designer had already filed a trademark and was already going through the process. Katy Perry, the American singer, then opposed the Australian trademark. She sort of went halfway through the opposition procedure and then dropped the opposition procedure. And it's not clear why she dropped the opposition procedure. But then the Australian designer's trademark went through to registration. The whole argument between the two of them went on for years. And in 2019, the Australian designer filed infringement proceedings against the American singer. Now, the infringement proceedings were relating to trademark usage relating to clothing lines, particularly where the singer was selling clothing brand name with her name through outlets such as Target, Myers, Kmart, a whole host of different stores. The American singer was also selling product through her companies. Now, she had a bunch of companies that she sells clothing through. One of them is called Killer Queen. The other one's called Katy Perry. And the court found that basically Katy Perry, the American singer, because she was using her own moniker, her own name, then that was used in good faith. However, the companies using her name, so the Killer Queen and the Katy Perry company, those companies were actually infringing her trademark. So the good faith defense didn't apply to these companies because they weren't actually using their own name. They were just using it under license. And that was an illegitimate use and an infringement of the trademarks in Australia. The court decided that basically the American singer or her companies were infringing. They awarded damages and costs for the Australian designer. However, they also awarded an injunction against those American companies trading in Australia, which is more important, which will stop them from selling in Australia without the Australian designer's permission. This is kind of a staggering outcome, considering this has been close to 15 to 20 years of disputes between the two parties. I think the take-home message is to register. If you want to protect your name, you've got to register your trademark early and make sure that you enforce it. There was questions in this case about how long the parties had taken to enforce their rights and that sort of thing. But I think most of the delays were relating to the fact that some of the parties, because they were actually discussing it between themselves, it never ever actually eventuated into a court proceedings until 2019, some years later. But I think the take-home message is really, if you want to protect your rights, register a trademark. It gives you a defense against infringement, but also it means that if someone is infringing your trademark, you can do something about it. The strange thing is that had the US singer, Katy Perry, registered her name in Australia, she would have had rights as well. And the two would have had to coexist and she wouldn't be up for trademark infringement. It's quite an interesting outcome. I hope this is helpful and I hope you gain some understanding about trademark law and some of the nuances about good faith in Australia. If you need any help with IP or trademarks in general, please feel free to contact myself or the team at Alder IP. We're happy to help you. Thanks.